afternoon, everyone. My name is Alvin Adjei. I have the privilege of being president of HYLA for this year. Before I introduce Kelly, I just want to give a reminder that today at 5:30 at Holman Draft Hall, there's going to be a Meet the Candidate happy hour that's going to be happening. So we encourage you to come so you can meet the people who are going to be running. The position of president-elect is contested. So there's going to be three candidates who will be going for president-elect. So they'll be in the position of leading the board after Kelly Haynen's year. So I would encourage you to come out so that you can see, because it's been almost half a decade since we've had a contested election at that level. And with that, I'm very excited to introduce Kelly Viktorin, who is one of our chairs of the Judicial Committee. Kelly?
Yes, so good afternoon and welcome to the Texas Supreme Court update. As Alvin mentioned, I'm Kelly Viktorin, and I am a personal injury trial lawyer with the firm of Armstrong and Lee. And as he mentioned, I'm also the co-chair of the Judiciary Committee. And I have had the distinct privilege of working with Brian for several years at our prior law firm. So I have no doubt that today is going to be jam-packed with lots of great information. So by way of introduction, Brian Humphrey is a trial and appellate lawyer whose practice includes both personal injury and general commercial litigation in both state and federal court. Brian is a native of Ashland, Kentucky, and he graduated from Campbell Law in Raleigh, North Carolina in 2010 and has been practicing law for the past 11 years. Brian is board certified in civil appellate law by the Texas Board of Legal Specialization. He has been selected to Texas Super Lawyers for 2021 and 2022, and he was selected to the Rising Stars list from 2016 to 2020. He is active in the HBA and TACTIS, and he is president of the Northeast Harris County Bar Association. After 7 years as an associate at Abraham Watkins in Houston, Brian left to start a solo practice, which his wife, Michelle, joined in 2020. So without further ado, I'm going to pass the torch over to Brian to start.
Well, thank you. And I'm going to try and not butcher sharing this PowerPoint. So let's see if we can do this. All right, so hey, Kelly, can you, is the screen shared right? I just want to make sure I'm good before we go.
Yeah, we can see it.
Okay,
yeah,
great, thanks. Okay, so, all right, well, good morning, oh, not morning yet, it's after lunch. So good afternoon. So since 2009, Jay Jackson, who also worked at the same firm as myself and Kelly and Alvin, authored an ongoing Texas Supreme Court update paper that he's given a lot over the years. And I joined him as a co-author back in 2013. So he and I have been doing this paper together for in our 9th year now. And so basically this paper and this presentation is a summary of all the Texas Supreme Court cases over the last year and a half. And we do actually have an ongoing paper going back to, I believe, 2009 and some older cases. It's a pretty big file. One thing I'll invite you to do, and I'll try and get this, I didn't put it on my PowerPoint, but I'll try to get my email address out to you. If you would like a copy of the paper, we're happy to share it with you and we'll have a list to send it out. We usually publish it once or twice a year. So usually we publish one in January. We may publish again after the term in June or July. So, but first off, I'd like to start with just a little updates on the composition of the Supreme Court. So right now we have, it's of course still an all Republican court as it has been for a very long time. There's been only one change. So currently the court is, you see in the back row, Busby, Devine, Blacklock, Bland, and Young. In the front row, the more senior ones are Lehrman, Chief Justice Hex, and just Boyd. So only one change since the beginning of 2021. as I'm sure most of you know, Eva Guzman resigned last year in order to pursue her ultimately unsuccessful campaign for Attorney General. She didn't make the runoff for Attorney General in the primary. In order to replace her, Governor Abbott appointed Evan Young, who's an appellate lawyer from Baker Botts in Austin. He's a former law clerk to the late Justice Scalia, to fill that vacancy. Evan Young is running for re-election to his seat. Justice Guzman's term expired this year, so that's going to be an election for a full 6-year term. He actually still had a contested primary. He won that primary against Dallas Court of Appeals Justice David Shank. So he'll be the Republican nominee in November, and the Democrat nominee is Julia Maldonado, who's a family district court judge here in Houston. Some of you might know her. So he's up for re-election in 2022. 2 other seats up for re-election. Justice Lehrman, who of course has been on the court since 2010. She'll face Erin Noel, who's another Dallas Court of Appeals justice who's running for her seat. And then Rebecca Huddle, who was actually appointed by Governor Abbott last year in 2020 in October to replace Paul Green. Because of how late she was appointed, she did not have to stand for re-election in 2020. So she is running for election to the new term. Green's term ended in 2022, so she'll be running for a full 6-year term. And her opponent is Amanda Rychek, who is yet another Dallas Court of Appeals justice. So lots of Dallas Court of Appeals justice running for the court. So far, none have been successful, and just to be frank, very unlikely that they will be successful this year. So on to our cases. So I'm going to highlight some of the cases. It's only a fraction of the cases we have in the paper. Just some of the cases that we thought merited a little bit extra attention. As most bar groups, is probably pretty litigator heavy group, and so these are going to be litigation heavy cases. We are mostly plaintiffs lawyers, so we have a little bit of a bias as far as what we're selecting. But again, we've summarized all the papers, and if you get the paper, one of the very useful things about it is we've broken this paper up into subject matter categories, and even each case is summarized a few different times based on their subject matter. So if you need to see the most recent cases that deal with, for example, oil and gas, there's a place for that in the paper. You can go see the most recent cases. You can see summaries of it. And that's always a great, at least, starting point for research, because usually at least one of those cases is going to give you a pretty good summary of where the case law is before. So you can, it's sometimes a lot easier to look at that than it is to just go search terms on Lexis. So again, I'll do my best to get my email out to you, or maybe you can put your email in the chat box. I may be able to see it. I'm a little inexperienced with giving these over Zoom, but I'll do my best to get you on the list so you can get a copy of the paper. So the first few cases we have are probably, a couple of them are very high profile cases, and they all sort of deal with federal preemption. So the first one was Enray Academy Sports, which was from June of last year. This came out of the Sutherland Springs mass shooting. So as I'm sure all of you remember, back in 2017, there was a mass shooting at a church in Sutherland Springs. The perpetrator purchased his rifle and some of the magazines from Academy Sports. And some of the family members of the victims and some of the wounded victims sued Academy for essentially selling the rifle to him, asserting they were negligent in doing so because he should have not have been able to purchase a rifle. So Academy moved for summary judgment under what's called the Federal Lawful Protection of Commerce or Protection of Lawful Commerce and Arms Act, which is Section 7902 and 7903 of the U.S. Code. And what that statute does is it prohibits suits against firearms sellers or manufacturers for simply selling a firearm that functions. You can sell them for products liability if the firearm malfunctions and injures you. You may be able to sell them if they actively violate the law, sue them if they violate the law, but you can't sue them simply for selling firearms if the firearm is used by somebody to hurt someone. So Academy filed a motion for summary judgment. The trial court denied the motion, and this is where the case is probably a little more important for general practice. Academy petitioned for mandamus, and the Supreme Court looked at the language of the statute, looked at the pleadings, looked at the evidence, and Supreme Court granted mandamus and ordered the trial court to grant summary judgment. And the reasoning was that here, based on the evidence, Academy was immune from suit because Academy complied with Texas and California law, Texas law in where the weapon was purchased, in Colorado, not California, sorry, where the shooter was from. And because they complied with the law under the statute, they could not be sued. And one of the important, probably the most important thing about this case, because most of us are not likely to have a lawsuit where you're going to meet these types of federal defenses very often. But where I think this case is very important for general practice is the court granted mandamus for the denial of a motion for summary judgment. Now, I'm old enough to remember that when you couldn't appeal the denial of the motion for summary judgment, you couldn't get generally mandamus for denial of a motion for summary judgment. But here, the court granted it because normally, in order to get mandamus, you have to have not only a clear abuse of discretion, but also an inadequate appellate remedy. Here, and almost always, the denial of a motion for summary judgment, you always have an adequate appellate remedy. You can appeal the final judgment in the case. Here, though, Supreme Court held that because of the language of this statute, which provides that the language says that suit may not be brought against these defendants. And the Supreme Court held that that means there is a substantive right not to be sued, not just a defense. So they actually cited a case called United Services, Enray USAA, which we're going to have a couple of Enray USAAs in this case. But in Enray USAA, they held that that was a case where a plaintiff attempt to refile suit, and USAA, after they'd already had a case dismissed, and USAA moved for summary judgment based on res judicata. And there the Supreme Court held that mandamus is important to avoid a wasted trial. And that's basically what we have here. The remedy of appealing an adverse judgment after trial is not adequate. You get to resort to a petition for mandamus to the Texas Supreme Court in order to not have to try this case. Does this mean that the camel's nose is in the tent? Does this mean that now we're going to see maybe more arguments for more petitions for mandamus for denied motions for summary judgment? Because if not, and if it's not just this case, I mean, how many other defenses can you point to where you might be able to argue you have not just a defense to liability, but some actual right not to be sued? For example, look at the reasoning behind the statute of limitations. The entire reasoning that you see in many cases is it's there to prevent litigation of stale claims, not just prevent liability, but prevent the litigation of those claims. So if I've got a clear-cut limitations defense, or at least I think it's a clear-cut limitations defense, I move for summary judgment and the trial court denies it, do I not have an argument that I should get have mandamus available in order to correct the trial court's denial of the motion for summary judgment, so I don't have to try a stale claim? Stay tuned, we'll see. Another case that's similar is Inray Facebook. So that's another fairly high profile case. And in that one, says there's actually multiple lawsuits, separate fact patterns, but all the same gist. They are all based on sexual trafficking or human trafficking, based on Facebook and Instagram, where the predators would contact and groom children on Facebook or on Instagram, and then ultimately lure them somewhere and sexually abuse them. And so the families of these victims filed suit against Facebook, who of course owns Instagram as well, and brought a large number of common law theories, negligence, negligent misrepresentation, things like that, but also brought a claim under, Chapter 98 of the Texas Civil Practice and Remedies Code, which creates a private civil cause of action for human trafficking. Unlike Academy, Facebook filed a motion to dismiss under Rule 91A, asserting that it was a baseless pleading because of Section 230, which you may have heard quite a bit about over the last few years. But Section 230 of the Communications Decency Act basically provides that certain types of internet service providers, which has been applied to social media platforms, are not liable for the content of their that's published on their platforms. They're not to be treated like a publisher. So Facebook filed a Rule 91A motion in all of these cases. The trial court denied these motions in all these cases. Like a motion for summary judgment, the denial of a 91A motion is not subject to the interlocutory appeal. However, courts have been a little more willing to grant mandamus in certain 91A cases, and they did here in part. So this was appealed to the Texas Supreme Court in all the cases. The cases were consolidated. Texas Supreme Court looked at Section 230, and lo and behold, Section 230 has that same language: may not be brought against these defendants. So the Supreme Court held that, again, there's no adequate appellate remedy. They have a right not to be sued here, a substantive right not to be sued. So the Supreme Court granted mandamus, ordering the trial court to grant the 91A motion, dismiss most of the claims, but not the Chapter 98 claim for trafficking. Using the liberal pleading standards of Rule 91A, again, there has to be basically no set of facts that would bring them within some sort of a claim that's viable. Here, under the liberal pleading standards, there was an allegation that Facebook encouraged violation of the law, basically engaged in illegal activity. And there's a statute that was passed more recently called the Allow States and Victims to Fight Online Sex Trafficking Act, or FOSTA, which clarified Section 230, and Congress provided in that statute that Section 230 can't be construed to prohibit a suit under the federal sex trafficking statute. And what the Texas Supreme Court reasoned was that because of that clarification, their interpretation that Congress also did not intend for Section 230 to immunize parties against liability under state sex trafficking statutes. So one question, of course, is this the same outcome in summary judgment? I'm sure we will find out if this case is not already on appeal on that. So does Facebook file a motion for summary judgment there? Higher standard, they're going to have to actually produce some evidence to that Facebook violated the law. And maybe this comes up again on the mandamus, and maybe it's a different outcome based on Enray Academy, because again, it's a very similar statute. So another case, this is less preemption, but it's fairly similar. So it's rather the political question doctrine. So this case comes from a Navy helicopter crash during a training exercise at sea. Three sailors were killed, one was injured. And so the families and the injured sailors sued the helicopter maintenance contractor, M1, under the the Death on the High Seas Act and under general maritime law. So the contractor filed a plea to the jurisdiction. They asserted the political question doctrine deprived the court of jurisdiction. Basically, the contractor blamed the Navy for using cannibalized parts. And so they asserted the Navy had some responsibility. And then they relied on an earlier case from 2018 that if anyone litigates any claims where the military may be involved, I highly recommend you read this case and this other case from 2018, which is American K-9 Detection Services versus Freeman. And in that case, a civilian in Afghanistan on an army base was bit by a war dog. It was maintained by contractors. So the civilian who received some money from the government under the workers' comp scheme that applies to civilian employees on overseas bases, then sued the contractor for damages. The contractor designated the Army as a responsible third party. They argued that they built their kennels in accordance with Army regulations, and then they moved for filed a plea to the jurisdiction, arguing that because we've designated the Army as a responsible third party, the court would have to evaluate the Army's military judgment in passing these regulations. Therefore, there's no jurisdiction because we can't have courts deciding on this essentially political question. The Texas Supreme Court agreed with that in that case, and they dismissed the case. All the defendant had to do was designate the Army as a responsible third party, and because of that, the court would have to second guess the Army's military judgment. That's a question that is committed to the executive branch, and therefore that's a non-justiciable question under the Texas Constitution. It would violate separation of powers. So in this case, 3 years later, M1 makes the same argument, but here the Texas Supreme Court disagreed. Unlike the prior case, this is not really military judgment they held. This is just simply aircraft maintenance. It's not military judgment it's not an application of military judgment in order to repair a helicopter properly. And here the maintenance contractor had primary responsibility to do inspections on the helicopter. So the Supreme Court held that this was not a non-justiciable political question, let it go forward. One thing that may have weighed on this is obviously these are 3 sailors who died and another one who was injured, whereas sometimes you can look at some of these opinions, the K-9 case, there was a bit of a skepticism about the merits of the plaintiff's claim in that case, so that could have weighed into this. The one question you might have is, well, why don't they sue the Navy too? But if you're familiar with this, while the government is liable generally under the Federal Tort Claims Act, there's something called the Ferries Doctrine that bars suits by service members for injuries in the course of activity incident to service. So here, M1 could point the finger at the Navy, but the sailors can't sue the Navy under the Ferries Doctrine because they were injured in the course of their service, and you can't sue the military for that if you're a serviceman. So next case we have deals with standing. Of course, in order to bring a suit, a plaintiff has to have standing. And one of the cases that deal with standing here is called Data Foundry v. City of Austin. This one, basically a consumer of electricity in Austin sues the city. The City of Austin runs a power plant, runs a utility. So the ratepayer sues the city, arguing that the city approved a excessive rate increase for its utilities. The city sought dismissal. They claimed that the Data Foundry didn't have standing because they're just like every other ratepayer. There's no discrete injury. This is a generalized grievance. Supreme Court held, actually, the injury here is we have a concrete particularized actual or imminent injury, check. We have an injury traceable to the defendant, yes. The City of Austin increased the rates. And a likely injury can be redressed by a favorable decision, yes, here too. So the Data Foundry had standing as a ratepayer, so a little bit different than the taxpayer case. Another one is Texas Propane Gas Association. Here, this was just a members of this gas propane association argued that there were inconsistent regulations passed by the city of Houston. Basically, the court just looked at this pleadings and determined they had standing alleged injury, actual or imminent harm from the inconsistent regulations. So they're standing here. Brumley v. Mcduff. This is more of a pleadings case. If you're in real estate litigation, you might know that statute says, property code says that the only cause of action for this type of action is trespass to try title. The Supreme Court looked at the substance of the petition rather than what it was called. So even though the plaintiff here didn't call it a trespass to try title action, they called it a quiet title action, the substance was really a trespass to try title claim. So the Supreme Court is going to look at the substance rather than the form of the pleading, and held that there was that this claim was valid. So we have a few personal injury cases. One is very important for everyone who's involved in personal injury, because if we do personal injury, you do uninsured motorist claims. So if you're not familiar with them, obviously, plaintiff injured in a car accident, if the defendant has no insurance or insufficient insurance to cover their damages, you can, and you have UM or UIM coverage under your auto policy, you can go after your UIM carrier. There was a case that all of us in personal injury practice know called Brainerd, which held that, yes, even though you're suing for benefits under insurance policy, you can't get attorney's fees under Chapter 38 for suing under a UM policy, because basically they held that even though they have a duty to pay your UM benefits, that duty doesn't arise until you have a judgment fixing the liability of the underlying tortfeasor and the amount of damages. So they can't breach their contract until you've actually sued not only the defendant, but sued them in a way that binds the carrier, either by suing the carrier as well or getting the carrier's consent to the lawsuit against the uninsured motorist. So until that judgment's in place, the carrier has no contractual duty to pay you. So you get no attorney's fees under Chapter 38 for breach of contract. Basically, it's not a breach of contract. Well, where does that leave us? Basically, the argument for years has been you can't get attorney's fees in uninsured motorist cases. But some plaintiffs' lawyers looked at this and decided, well, if they haven't breached a contract yet, how can I sue them? Well, what we usually do in order to fix the rights of the parties in a contractual dispute where there's no breach yet is a declaratory judgment action under Chapter 37. And the Texas Supreme Court held, and in this case, AllState Insurance Code v. Irwin, yes, you can do that. You can file a declaratory judgment action to recover UM benefits. And why is that important? Because Chapter 37 includes a discretionary fee shifting provision. So there's at least the chance of recovering attorney's fees in one of these cases. And if you've litigated uninsured motorist claims, you know that the fact that the carrier is essentially not liable for any more than the policy limits and before didn't have to pay attorney's fees meant that they didn't have a lot of incentive to settle with you, especially when they were defending the case with staff counsel. This may give you a little more incentive than a little more incentive to pay. So this is very much a big deal for anyone who litigates these cases. This is pretty much, while fee shifting under Chapter 37 is not mandatory, it's still discretionary, it's still a pretty big deal. So I encourage you to look at this case if you handle UM litigation from either side. Another uninsured motorist case, we've got a few of those this time around, Enray State Farm. So there, also after Brainerd, the argument has been that if you sue a UM carrier for benefits, you also sue for insurance code violations. Because the carrier doesn't have the obligation to pay until you fix their liability, they can't be liable for insurance code violations unless you proven your entitlement to benefits. So courts of appeals have fairly routinely held that the carrier is entitled to bifurcate trials on the insurance code violations, so that the plaintiff has to prevail on their basic claim or UIM claim before they can try their insurance code violation. And in fact, the discovery on the insurance code violations is typically abated until after the first trial. The Supreme Court did what basically every single Court of Appeals has done, not very surprising. And there is one difference. If you can show independent injury, and which is pretty difficult to show, if you can show an independent injury due to the insurance code violation, you may be able to keep that in the case without bifurcating it. Next one's USAA. In one of two USAA cases, this is another uninsured motorist case. And what happened here was, so the plaintiff sued the defendant and sued the carrier. Sued the underinsured driver and sued the uninsured motorist carrier. The suit against the uninsured motorist carrier was abated, and then the plaintiff went to trial against the driver and got a $160,000 verdict. The driver only had $30,000 in coverage. So while the plaintiff obviously got a verdict well in excess of the $30,000 coverage, the plaintiff was not very satisfied with that number, thought his damages were much more than that. So it's not discussed in the opinion, but there must have been a Stowers claim, because the plaintiff then post-trial, but before a judgment, settled with the drivers and liability carrier for just about the amount of the verdict. And as a result of that, entered into an agreed dismissal with prejudice, not a judgment on the verdict. Then the case against the uninsured motorist carriers restarted. Well, the uninsured motorist carrier, they liked the $160,000 number, and they also liked that number had already been paid. So the UIM carrier, they moved to enter judgment on that verdict. They argued that the plaintiff is collaterally estopped from relitigating the amount of damages by that verdict. Generally under collateral estoppel, or we also call that issue preclusion, a party can't relitigate an issue that they've already tried. But one of the essential elements is a final judgment. In fact, the Texas Supreme Court held here that even though this issue had been tried and they had a verdict, because there was no judgment on that verdict, there was no collateral estoppel. Even though, and this is the case, even though the dismissal was with prejudice, basically, if there's just like as if there was a new trial order, if there's some other dismissal ordered and not a judgment on the verdict, that verdict is unenforceable. It's as if it never happened. So while the plaintiff can't walk in and of course can't bind the UIM carrier to the verdict in that case, the UIM carrier can't hold the plaintiff to the verdict. So basically the plaintiff gets to go try their UIM claim and gets a second trial on their damages and may get more than 160, which is what the plaintiff wanted here. So actually it's a pretty good case for plaintiffs. If you do these claims, you might imagine some ways you can use this. Another personal injury claim, this is a products case. Basically, the plaintiff was badly injured when a generator had a terminal venting incident, basically exploded and burned the plaintiff very badly. The jury found the manufacturer liable on a design defect. If you follow products cases, you may remember a case called Genie from a few years ago, where the Supreme Court went through a very detailed analysis of the design defect evidence and basically second guessed the jury. They were told that there was no legally sufficient evidence, but they had to really look at the evidence to reach that holding. Here, the Supreme Court actually upheld the verdict. So this is a good case to contrast with the Genie case if you want to see what is legally sufficient evidence to support a verdict on design defect. Basically, there's the Grinnell factors, which you can see here, which are basically a risk utility analysis to figure out whether a product is unreasonably dangerous. Of course, they're not strictly liable for the product unless it's unreasonably dangerous. And so we look at this evidence here. Service of process. These cases are always kind of interesting. So we've got a couple of these. And of course, anyone involved in litigation needs to know this very well. As you probably know, of course, the case law repeatedly says strict compliance with the rules on service of process must appear in the record for a judgment to stand up on a direct attack. And here we have an employee sued an employer and then served after the employee was bitten by a dog and sued the employer on a non-subscriber case. Plaintiff was unable to serve the employer at a certain address and obtained substitute service. There was a Rule 106 order. And then after that, they served the defendant. Defendant didn't answer. There was default judgment. And then it was reversed by the Texas Supreme Court. Why? Well, the 106 order authorized service at Heathers Hill Drive. The service, the return of service at Heather Hills Drive. And there you go. So, because there was no evidence in the record that Heathers Hill Drive and Heather Hills Drive was the same street, the Supreme Court held that there was no strict compliance with the Rule 106 order. 106 order only authorized service at Heathers Hill Drive. It did not authorize service at Heather Hills Drive. So, you can imagine the lesson here. If you get a default judgment, you need to really look at every single document, and even down to the letter, the positioning of 1S on your street name is enough to subject your default judgment to reversal. Another lesson is probably if you get a default judgment, tell your client that there's a decent chance it's going to get thrown out at some point if someone shows up to contest it, because the truth is, and I've done a lot of these in practice. I've probably had half a dozen cases where someone came in and had default judgment against them, and I've had a pretty good success rate getting them reversed because there's almost always something wrong with them. Almost always. I've almost never seen a default judgment that didn't have at least one problem with it. And this shows you why. Another case. I don't have the slide for it here, but another case is WWLC Investment versus Miraki. That's another service of process case. And in that case, the tenant sued a landlord. The landlord was a limited partnership, and it was served by substitute service on its owner, president, and CEO, quote unquote, whose name was, I believe, Chen, and got a default judgment. But then the limited partnership shows up, finds out about the default judgment a year later and files a bill of review. And here's the problem. A limited partnership by statute has to be served by service on its registered agent or its general partner, not a CEO or owner or president. So again, there was no evidence that the person who was served was the general partner or the registered agent. And in fact, the general partner and registered agent were different entities. And so there, the Supreme Court held that the bill of review had to be granted. One thing that's important to always remember is that you don't have to prove all the bill of review elements if you've got bad service or even just defective service. Only the defective service needs to be proven, and that entitles you to have the judgment set aside. So again, another case where some default judgments get set aside. Next case we have here is sometimes we have interventions. This is an intervention by a CPA. So condo owner was sued by his homeowners association, and the condo owner's CPA intervened in the case. The HOA settled with the condo owner, and then the trial court struck the intervention and then rendered judgment. The CPA filed a motion for a new trial and then sought to appeal it. So there was a dispute about the appellate deadline. So basically, the question was, when did the CPA have to file his notice of appeal? So the 30-day deadline is extended when any party files a motion for new trial. So the question was, is the intervener a party? And that depends on whether he attempted to intervene before or after the final judgment was signed. And if after, the intervention can't be decided until the judgment is set aside. So here, because the intervener had intervened before judgment, his filing of a motion for new trial extended the appellate deadline to 90 days, and therefore his appeal was timely. So the next case we have here, and this one's can become pretty critical here, is electronic signatures. So this comes up a lot if you handle any employment claims. Basically, employee goes to work for a defendant, and then as often happens, I mean, some of us who are a little older remember sitting there at a table and signing a bunch of pieces of paper before you start work. Well, nowadays, that's all done by computers. So the employer gives you a login and password, and you go log into their website and click through a bunch of things, give your social security number, and almost always, or at least a lot of these cases, you click yes on an arbitration agreement. So what happens? Plaintiff or the employee then sues the defendant for whatever, non-subscriber case, discrimination, what have you, and the defendant files a motion to compel arbitration and pulls out a piece of paper that has a printout that shows the arbitration agreement and then maybe a typed name and an IP address at the bottom, not a hand signature. So plaintiff says, I didn't sign that. I've never seen that before. That wasn't me. So the question is, what does the court do? And what the Supreme Court held, that of course this is electronic signatures are of course enforceable under the Chapter 322 of the Texas Business and Commerce Code, which is the Texas Electronic Transactions Act. And what the employer did was have a witness put on evidence, I think by affidavit here. This is how our process works. This is how we give them their login and password, and this is how they can't log in. If they do that, the plaintiff simply saying, I didn't sign that, is not enough. That doesn't even create a fact question. The court, if that's the only evidence in the plaintiff's favor, the court must grant the motion to compel arbitration, must compel arbitration based on that contract. I will tell you, I actually litigated this exact issue, this exact fact pattern while this case was pending. Thankfully, we resolved our case before this came down, because that would have been embarrassing. Though I think we knew this was going to happen. Another case is Enray Auto Crushers. If you're in personal injury practice, you may have heard of a case called Enray North Cyprus, where what happened was some plaintiffs sued North Cyprus Medical Center, which is a hospital in the Northwest. Back then, they were fairly notorious for being very aggressive about filing and litigating hospital liens. So some plaintiffs' lawyers decided to sue them and get some information on their the rates that they're paid by health insurance companies, to argue that their hospital liens were excessive. And the Supreme Court in that case held that those negotiated rates were discoverable, they were relevant, so they had to be produced. And so now, while plaintiff lawyers got a pretty good win in North Cyprus. The pendulum kind of swung the other way. Really, it's the same case law. It's just now the defendants are using it. So here the plaintiffs treated under a letter of protection, and then the defendant thought the charges were unreasonable, as they often do in letter of protection cases. So the defendant decided to ask for the negotiated rates for the healthcare provider. And the healthcare provider argued that you can't see these because these are confidential and they're not relevant. The trial court refused to compel the production, and the defendant sought and obtained a mandamus for the Texas Supreme Court. Supreme Court held here there was no evidence showing that this is burdensome, and if there's a confidentiality problem, the protective order can address that. So ordered the healthcare provider to produce the contractual rates. A few discovery cases here. Enray Copart, basically, we'll try to, I know we're getting a little late, there's so many cases to talk about, but these are fairly important here. Copart's a very good case for someone resisting arbitration because it shows when a court may authorize discovery before deciding a motion to compel arbitration. If the court cannot fairly and properly make its decision on the motion to compel arbitration because it lacks information regarding the scope of an arbitration provision, then it can and should authorize limited discovery. Inray USAA, another UIM case, different than the one we talked about before. This one, the plaintiff wanted to depose the corporate rep of USAA. USAA said they moved to quash that deposition. They argued that, look, our corporate representative, we weren't there. We don't know anything about the accident. So we have no relevant knowledge. So you shouldn't be able to take our corporate representative. Supreme Court said, no, that's not how it works. You always have the right to depose the defendant or propose the opposing party. And just because they lack personal knowledge doesn't mean they lack any knowledge. Obviously, you get to ask them about their contentions, even if they don't know what happened. So a good case for anyone trying to take a corporate rep deposition. They can't be resisted just because the defendant doesn't specifically know anything. But you know, some of their topics were disallowed here. So the next case is called the Enray Texan Millwork, which is a wrongful death case. And here the trial court compelled the defendant to produce a former employee for deposition. Basically, the defendant took while the employee was still working there, the defendant took a witness statement and produced it. So the plaintiff wanted to go depose that former employee. However, the trial court compelled the defendant to produce that former employee, but the Supreme Court held no, you can't do that. A party can only be compelled to produce a witness if the witness is retained, employed, or controlled by the party at the time of production is requested. So you don't have to go out and hunt down your former employees to produce them for deposition. Inray Christensen is a jurisdictional discovery case for special appearances, and this is an important one because they actually set out a new standard, and the standard is the information has to be essential to prove at least one part of the plaintiff's theory of personal jurisdiction. These topics, in that case, involved the plaintiff filed or served a notice of a corporate rep deposition with, I think, 30 topics. The defendant thought these touched on the merits, they're impermissible. It was a Canadian engineering firm, and this is a commercial products liability case. And the Supreme Court held the topics can overlap with the merits, but they still have to be essential to prove part of the plaintiff's theory of personal jurisdiction. But ultimately, even if they meet these standards, they also have to comport with general discovery principles. And they held here that the topics were overly broad under general principles, and they encompass too many non-essential topics. So they granted mandamus, ordered the trial court to look at these topics again and narrow them down. Another deposition case, Enray American Airlines, they sought an apex deposition, and the plaintiff here, the Supreme Court granted mandamus, and the Supreme Court held the plaintiff failed to show that the executive had been a uniquely superior personal knowledge of discoverable information. So unlike a corporate rep, you can't just depose the CEO. You can always depose the corporate rep. You can't always depose the CEO. Actually, usually you can't. The last few cases I'm going to talk about before I skip to the end are a few cases on attorney immunity. And so you may be familiar with a few older cases. One from 2015, Canny Hanger v. Bird. Basically, if you can't, a non-client cannot sue an attorney for conduct that is within the scope of representation, even if it's wrongful. And we look at the nature of the conduct. So if it's not foreign to the duties of an attorney, the attorney is immune from liability to non-parties. So if you think that, and this was in a litigation context, you think the other guy's lawyer defrauded you in the course of litigation, you can't sue the lawyer for that under the attorney immunity doctrine. And there's another case called Youngkin v. Hines. More recently, this was similar. This was an anti-SLAPP case. And again, they held, I believe that was a fraud in the course of a divorce proceeding. They actually, the Supreme Court reversed the denial of an anti-SLAPP motion and held that negotiating and entering a settlement agreement and preparing documents are within the scope. And even if you've alleged that the defendant has, that the lawyer has committed fraud in doing that, you can't sue the lawyer for that. Just because it was fraudulent doesn't mean it's foreign to the duties of a lawyer. So those two cases were very strong for attorney immunity. We get another case. So of the two cases we have this year, one is Haynes and Boone versus NFTD. This was not in the litigation context. So the question is, does immunity apply to that? In the Court of Appeals here, the Court of Appeals actually held that the attorney immunity doctrine was limited only to the litigation context because that's an adversarial proceeding. Supreme Court disagreed. So as long as the relationship is adversarial, you also can't sue the opposing lawyer in a business transaction too. So if you think that the lawyer for the buyer of your contract and you represent the seller, if you think the lawyer defrauded your client, that lawyer is still immune under the attorney immunity doctrine. However, there's another case called Landry's v. Animal Legal Defense Fund. So basically what happened here was the Animal Legal Defense Fund, they went through the downtown aquarium, took some pictures of the tiger down there, and asserted that the tiger was in inhumane conditions. So they were going to file a citizen suit under the Endangered Species Act. Before you can do that, you have to file a letter with the Department of Agriculture outlining the claim to basically give the USDA the opportunity to go and file the suit themselves. So the ALDF and its lawyers did that, and then they sent the same letter to the media. So Landry's sued them for, Landry's, who owns the downtown aquarium, sued the ALDF and the lawyers for defamation and some other claims. And the lawyers and the ALDF prevailed in a anti-SLAPP motion, arguing both litigation privilege and attorney immunity. Litigation privilege is the idea that statements made in the course of litigation are privileged, and you can't they can't be the basis of a defamation suit. For example, a witness says something on the stand, pleadings filed in court, even if they're defamatory, even if they're false, your remedy is sanctions, not a defamation lawsuit. However, in an opinion that frankly surprised me, the Texas Supreme Court reversed and held that the attorney had no immunity here because repeating your client's allegations to the media or the public for publicity purposes is not acting in the unique lawyerly capacity to which Texas law affords immunity. It's a very different outcome from the other case, from the Hainsman case. It also held, and it's not noted on the slide, they also held that the litigation privilege only applies to statements in litigation. So if you take a pleading, even if it's the same exact pleading, and give it to the reporters, now you can be sued for defamation. So if you are inclined to make a statement to the media about your case, do not assume that you're protected from liability for it. Don't assume that the defendant can't sue you personally for defamation. They have to defend that. So a word of caution here. One last case that we'll talk about before I move on to our little chart. Enray AllState. If you use 1801 affidavits, now what the Supreme Court held was that first off, they can be signed by non-healthcare professionals. So if you've got someone who is, so under 1801, as you may know, an affidavit that the medical expenses are reasonable and necessary can be filled out by a non-expert custodian of records, and that's sufficient to prove reasonableness and necessity even without an expert, unless it is controverted. And the case law had been the controverting affidavit has to be signed by an expert. Well, here they held even a non-healthcare professional can sign it. So if someone's simply a coding expert who just, they don't know about, they're not doctors or even nurses, but they are familiar with billing, that's enough. So it somewhat lowers the bar for filing a controverting affidavit. And even without filing a controverting affidavit, the defendant can still challenge reasonableness and necessity of trial. That's a departure from what the courts of appeals have said in this case. So our opinion is that 1801 affidavits are pretty much dead. I mean, you can still use them, but in any case, it's very well contested. The defendant can easily render them useless and make you call your expert to trial to prove these damages up. So I'm going to skip ahead here to what we have, the tote board. So in addition to summarizing all of our cases, we decide who the winners and losers were. Count plaintiffs and defendants here. Defendants won 57.8% of cases. So decisive wins for defendants, but not as decisive as in years past. We break them down by what type of parties, individuals, businesses, etc. Win and lose. Maybe not surprising, business defendants do very well. They're 42-20 as defendants in the Texas Supreme Court. Government did better than others as plaintiffs, 7-7, 7-3. And then insurers, of course, did very well. They won. They're 9-8 as defendants, but they're 2-0 as plaintiffs. We also, because we're plaintiffs lawyers, do a narrowed analysis on just the specific types of cases that plaintiffs lawyers handle, personal injury insurance cases, Tort Claims Act, things like that. And there, unlike most years, the plaintiffs actually did a little bit better in those cases. They went 34-42. So we're right up here at 1 o'clock. So I want to thank you very much for listening. And again, I hope that I haven't seen the chat box here. I've seen a couple chats. But okay, I see Kelly gave you, so if you check the chat box, Kelly gave you all my email address. So please, if you would like a copy of this paper, go ahead and send me an email and I'll put you on the list. And I'll probably be sending out here in a couple of weeks. So again, thank you.
Well, thank you so much, Brian. That was super informative, and I know on behalf of HYLA, we really appreciate it. Just 2 housekeeping items. In that chat box is the CLE course number. I'll repeat it for some of you just in case you have something to write it down with, but it's 174151639. And I also included his email if you want to request his paper, brian@humphrey.PLLC.com. So hope everyone has a good rest of their day.